Before we dive into those regs, we're going to just do a very quick update on where things stand with respect to conservation easements. We're going to begin with Kathy. This is at page 3 of your materials, the Briarcreek Preserve decision.
Briarcreek is another conservation easement case, and it also involves what is known as the proceeds on extinguishment provision of the regulations. And that provision says that in the event that the conservation easement is extinguished by a judicial order, condemnation, that kind of thing, then the donee, the charity, is supposed to receive a proportion of the proceeds equal to its fraction of the value of the conservation easement. And what the service has said is that means that you can't reduce that value, that fraction, by any post-conservation easement improvements. And this was the issue in Hewitt, and Briarcreek, following Hewitt, claimed that the conservation easement proceeds on extinguishment regulation was invalid. Hewitt said it was invalid because of the Administrative Procedure Act and the fact that Treasury did not follow up or respond to one of the comments that was given to it by the New York Land Trust. And basically, this court said, we're just going to wait and see. We're not going to rule on this summary judgment motion. We're not going to say whether we agree with Hewitt. Absolutely, they're going to agree with Hewitt if the case finalizes, because it's appealable to the 11th Circuit, which is the circuit that Hewitt was decided by. But right now, it's on a hold.
Which is an interesting notion. The tax court basically saying, we don't like the result in Hewitt. We're not going to buy into it. We're just going to hold off for a while. And that's really reflective of what's going on in Hewitt at the present moment. Larry, tell us about that at page 4.
I thought also I would spend just a minute to remind people what a conservation easement is. Most of the planners don't do conservation easements. And the idea of a conservation easement is I own a piece of property and I put an easement on that prevents certain kinds of development, which can detract from the environmental protection of the property. And my deduction is based on the difference between the value of the property before and after I impose the easement. You can also do that for a facade on a historic building, for example. And again, the deduction is based on the difference between the value before and after the facade easement is placed. All these cases that we look at, it seems to be every one of these programs is a case involving the language that says once the easement is extinguished, for example, the property would be taken by eminent domain, for example, or some other reason such as that, or for some other reason it's impossible to preserve the easement, then the proceeds on the sale of the property have to be allocated in a way that preserves the interest of the charitable beneficiary of the easement. And all these cases involve failures to comply with the very specific language in the regulations. Also, some of these cases involve syndicated ones, which are considered abusive for a number of reasons by the service. Some of these cases we've looked at today are not that kind of syndicated case. The language in Hewitt was, again, involving these very specific allocation language. And here the taxpayer made the argument that the regulation itself was invalid under the Administrative Procedure Act because not all of the formalities were followed in the APA, including commenting on one of the specific comments that had been made on the proposed regulations. I think there's a real message here. I think more and more in tax cases where, especially where you have a weak case on the merits, you'll attack a regulation as not having been promulgated in accordance with the APA. And I think we'll be seeing more and more of that in tax cases. And it may be that if you have a tax case that involves a regulation, you pretty much have to look at the administrative history to see whether the APA was complied with, because the courts seem much more willing now than I would have guessed to strike down regulations on that basis. In the Hewitt case, The Supreme Court will not be hearing this case immediately. The government has decided not to appeal, probably because it wasn't final in the tax court yet. It was remanded for further proceedings to the tax court. At one point, the Supreme Court will have to get involved in this conflict in the circuits between how different circuits are interpreting this very technical language in the regulations on extinguishment.